I'm Dr. Nidhi Mathur, Area Chair Human Resources at IMT Center for Distance Learning. I welcome you all to this session on nuances of the Indian Constitution. And we are holding this session because we had our Constitution Day on 26th of November. We are very proud of our constitution, and we thought that there should be someone who can, actually make us understand the meaning of constitution and the spirit of constitution, most importantly, which I think that we are losing day by day. So let me invite Mr. Prateek Som. He's going to be the speaker for today's session. And to introduce Mr. Som, he is distinguished lawyer with a master's degree from Harvard University, where he was a full scholarship recipient, and an LLM from National Law University, Delhi. Over his 14-year career, he has held pivotal roles in government, multinational corporations, and litigator. Mr. Som has transitioned to litigation in the Supreme Court of India and various high courts, representing clients from diverse backgrounds, including cabinet ministers, Bollywood celebrities, Indian cricketers, and leading corporate houses. Since 2021, he has served as standing counsel for the government of Haryana in the Supreme Court, defending the state on critical civil, criminal, and policy-related cases. He's also the national spokesperson for the Jananayak Janata Party. His expertise extends to international forums with regular appearances on CNN, India TV, making him a leading voice on legal and political matters. Prateek has been recognized as one of the India's 100 under 40 by Fox Story and has been appointed legal counsel for the National Commission of Women and Steel Authority of India Limited. His thought leadership includes articles on hate speech, constitutional matters, data privacy, white-collar crimes, and uniform civil code. And he has actively contributed to public policy through initiatives like Haryana Local Candidates Employment Act. His academic credentials are complemented by training from premier institutions, including Harvard Law School and IIM Bangalore. He is also deeply involved in pro bono work, environmental initiatives, and advocating for the welfare of aspiring law students. So I welcome you, Mr. Som, and the forum is all yours. I'm sure our students are going to gain a lot from your speech.
Thank you, Dr. Nidhi, and my personal thanks to Dr. Ashok Sharma. This has been an absolute honor and privilege and a pleasure to talk about Indian Constitution, something under which we all litigators, all constitutional experts, and in fact each Indian operates. This is a vast topic to discuss, but as we near the Constitution Day, this is something very pertinent that we talk about. And what I've learned is that the audiences are non-legal background, so I will try to be as basic as I can so that the understanding on the constitutional framework of India is to the maximum. So if we'll talk about the Indian Constitution, so Indian Constitution per se, it is just not a legal document. It is basically a soul of our democracy. When it was crafted with a vision of balancing the diverse interest, because at that point of time our country was shaping up into a new country, and it was almost 2.5 years when we were about to give constitution to our country, and the framers of constitutions were under the pressures that they were the different social fabrics, religious fabrics, and it was a sensitive time when the Constitution of India was framed and then implemented. So the basic purpose was to safeguard the individual rights and freedoms. And after independence, the basic need was that India needed a guiding framework, a book through which the country will operate, with the aim that the unity of its diverse population is there. So as we all know, Dr. B.R. Ambedkar led the drafting process. There was a constituent assembly, but Dr. B.R. Ambedkar was leading it. He was one of the main person who drafted the Indian constitution. He, of course, because of his vast the exposure at a global level, he took examples from United States, UK, Ireland, and some more countries, and he was well traveled, he was a learned man, so he had lot to rely upon and lot to emulate upon. The drafting process of our constitution was almost 2 years. It was specifically, it was 2 years and 11 months. And this constituent assembly was formed just before we attained formal independence. It was the constituent assembly was formed in 1946. It was adopted in 26th November 1949, but later, after 2 months, on 26th January, we it came into effect. The basic, the words which came into existence after the implementation of the constitution was that our country is a sovereign, socialist, secular, and democratic republic. If we'll talk about the key features of our Indian constitution, this is one of the largest, longest constitution with almost 448 articles and 12 schedules in it. And it talks about the basic structure which I'm going to talk about, and this will clear a lot of points that how the basics, that how this country operates under the basic structure which has been given by our constitution. So basically, if you'll see, our Indian constitution is something which has a blend of rigidity and flexibility too. So, as per se, if we have to give a statement, I would say that it is a synthesis of both. It is neither rigid nor flexible. For example, the Article 368, it provides for two type of amendments. Some provisions can be amended by majority of the parliament, that is almost two-third of majority of members of each house present and voting, and the other provisions can be amended by a special majority of the parliament with the ratification of half of the total states. Some provision of the constitution can be amended by a simple majority of the parliament in the manner like it can be in the ordinary legislative process. The important essence of Indian constitution is that we have a federal system but with a unitary bias. What I mean to say by this is that the Constitution of India establishes a federal system of government. So that is our central government, which I'm talking about. It basically contains all the usual features of federation. That is the two governments. Two governments means the state government and the central government. Then there is a division of power among the two governments. Some laws are in the state subject, some laws are in the central subject, and some laws are under the domain of both the governments. That is called some laws under the concurrent powers. So other point, this establishes that we have two form of government, one with at a central level, one at a state level. Then there are two important things which I want to mention. Is one is that there is an independence of judiciary. So under a basic structure of framework, we have three organs, that is judiciary, legislative, and executive. So far as judiciary is concerned, we have an independent judiciary, and there is a concept of judicial review as well. However, the Indian constitution contains a large number of unitary non-federal features, like it is a strong center represented nation. There is a single constitution. It does not mean that state of Andhra Pradesh will have a separate constitution, state of Maharashtra will have separate constitution. There will be a single constitution for whole of the India. I'm sorry. Then there is a concept of a single citizenship. If you are a citizen of India, that is good enough. You don't need to prove your citizenship through any of the state. Then there is a system of integrated judiciary. Otherwise, the head of the state becomes the chief minister, but the appointment of the state governor is done by the center. So that also brings to the point that there is a federal system with unitary bias. The term federation has been used in constitution in article 1. That is, it talks about, it describes India as a union of states, which implies two things. One is Indian Federation is not the result of an agreement by the states, and then no state has the right to secede from the federation. So, you know, I'll give a live example that there is a demand of carving out Khalistan from India, and there are some separatist group which talks about seceding from the Federation of India. So our constitution gives this power that no state has the right to secede from the federation. So federation is the central government, the Federation of India. So no state can ask for separation from India. That power has been given in the Article 1 of our constitution. Then the Indian constitution has been variously described as federal in form but unitary in spirit, or maybe quasi federal, where federation with a centralizing tendency has been established. Now I'll come on the form of the government. The form of the government in India is basically a parliamentary form of the government. The Constitution of India has opted for the British parliamentary system, and because we derived most of our laws from the Britishers. If you'll see, half of our laws operating in India now is more than 100 years old. In fact, before the recent amendment of Indian Penal Code and Criminal Procedure Code, we were operating. This country was operating on the same laws which was formed by the Britishers. So we also, inherited the parliamentary system which was there in with the British. So India also has a parliamentary form of, a government. The constitution establishes the parliamentary system not only at the center but also in the state. So the features of, the parliamentary government in India are that there is a presence of nominal or real executives. Which party rules the government is the party which gets the majority. The collective responsibility of the executive to the legislature is there. Then membership of ministers is in the legislature. That is, the minister should be a legislator. So that is a condition precedent to become a minister. Then leadership of the prime minister or of the at the center, and the chief minister at the state level. So even though the Indian parliamentary system is largely based on, the British pattern, that but there are some fundamental difference which I want to point out. For example, the Indian Parliament is not a sovereign body like the British Parliament. The Indian state has an elected head like a republic, while the British state has a hereditary head like a monarchy. So we are absolutely a republic form of government, while we inherited a lot of laws, our customs from the British state, but the hereditary head is the monarchy. So if we talk about the prince and the queens of the British, that is not, they do not have an executive power, but they have a hereditary head. So the son of a prince will become a prince, but here the son of a prime minister will not become a prime minister. So we have an absolute republic form of the parliamentary system. I'm sorry, I have a bit of a scratchy throat, so I'm sipping my tea along with this. I'm sorry. Right. So now the synthesis of the parliament and the federation. So just a second. So we have talked about the independence of judiciary, and we have also talked about the parliament sovereignty. But a normal question arises, which is supreme? So the answer lies in my points that the doctrine of sovereignty of parliament is associated with British Parliament, while the principle of judicial supremacy is with that of our American Supreme Court. This is very interesting point if you'll understand. This particularly talks about that we have inherited the parliamentary form of system from British Parliament. But how our judiciary operates is basically inheritance of on principles of judicial supremacy, which has come from the American Supreme Court. The American Constitution provides for the due process of law against the procedure established by law. So we also operate on the same. Therefore, the framers of Indian constitutions have preferred a proper synthesis between the British principle of parliamentary sovereignty and the American principles of judicial supremacy. The Supreme Court, on one hand, can declare parliamentary laws are unconstitutional through its power of judicial review. So this word judicial review, I want to talk about it. Being a lawyer, it is very important that I make you understand that what is the concept of judicial review. In India, it is said that the biggest litigator in the courts is the government. Why the government is the biggest litigator? Because all the cases against the government goes in the court, and the court decides whether the government or the petitioner or the appellant is correct or not. So what does this imply? This implies that court holds the authority to hold government or the state wrong or right. So that is the power of judicial review. That courts have a power that they can, the constitutional courts, which includes the High Court and the Supreme Court, that they have a power to review whether any law made by the Parliament or by the State Assembly is correct or not. So they have a power to nullify that law or to uphold that law. This is a very important, power on which all the constitutional courts operate. So judicial review is something that cannot be amended, that cannot go away, and that gives a judicial supremacy to all the courts in our country. On the other hand, the parliament can amend the major portion of the constitution through its constituent power. So when I'm talking about the independence of judiciary, I must mention that the Indian Constitution establishes a judicial system that is integrated as well as independent. The Supreme Court stands at the top of the integrated judicial system in the country. Then there are different high courts at the state level. Under a high court, there is a hierarchy of subordinate courts, which are also called as district courts of, or the other lower courts, that is the magistrate courts. So this is basically a hierarchy. So the single system of, the court enforces both the central law as well as, the state laws. Now, the Federal Court of India is the Supreme Court, the highest court of appeal. It is the guarantor of fundamental rights of the citizen, and it is the guardian of the constitution. So Supreme Court holds a special relevance so far as our constitution is concerned, so far as our country is concerned, because it is the highest court of appeal. It is basically, it guarantees the fundamental rights which is given by the constitution to us, and it is the guardian of our constitution. So if there is any attempt to change the constitution or to bring any amendments, then the Supreme Court, through the power of judicial review, holds the power that they have the last say in this. So the constitution has made various provisions to ensure its independence, including the security of tenure of the judges, fixed service condition for the judges. This means that the judiciary is not dependent on the executives. I'll give you a small example that how our chief justices are, pre-decided. So it depends that which judge in the Supreme Court is the senior most, and the tenure is destined on the remaining age difference till the age of 65. So that is something, that is something which we have to understand, so far as appointment of chief justices or other Supreme Court judges are there in the Indian constitution, that up till the age of 65, whoever is the senior most judge becomes the chief justice and gets retired when he attains the age of 65. So why I'm making this argument is that the executive has no power. The ministers, the government has no power to interfere in the internal affairs of the judiciary. They have a fixed service conditions. They have a fixed tenure of the judges, so that makes them, independent in this sense. Now I'll talk about when we are talking about the Indian Constitution, we must understand that there are fundamental rights which has been guaranteed by our Constitution, and as the Indian citizen, you must understand that what are your fundamental rights which are guaranteed and that are non-negotiable. So first and foremost, we have a right to equality. Each and every citizen in our country is equal as per the constitution. We have a right to freedom. We have a right to freedom, that is mentioned in articles 19 to 22. We have a right against exploitation. No citizen of the country can be exploited. The constitution gives you this guarantee. Then there is a right to freedom of religion. So any citizen has a right if they want to practice Hinduism, if they want to, adopt Muslim, Islam or Christianity, it is their absolute right, and state cannot interfere in these decisions. Then, Article 29 and 30 guarantees the cultural and educational rights. Then there are constitutional remedies which are guaranteed by Article 32. So these are the Indian Constitution guarantees, which are the basic six fundamental rights. There are some fundamental rights which have been derived by the judgments. So, for example, in 2017, we had a famous, Constitution Bench judgment. So, I'll also talk about the Constitution Bench. So, when there is the largest bench which gathers together and decide on the constitutional matters, when they give a judgment, then that judgment is called as Constitution Bench judgment. So one fundamental right which has been given by the Constitution Bench as last as 2017 was right to privacy. So this has come in 2017 through a judgment called Putta Swami judgment, through which the Indian Constitution guarantees you your right to privacy. So no, the government cannot interfere in the privacy of its citizen, and that that right has been guaranteed by a constitution bench in 2017 in Putta Swami case. Then there are directive. These are the rights which we have talked about. Then there are directives of, directive principles of the state policy. So in our constitution, it is written that what B.R. Ambedkar, Dr. B.R. Ambedkar thought of the directive principles of state policy. He mentioned that these are the novel feature of the Indian constitution. They are enumerated in part 4 of the constitution. So basically, there are three, categories which have been defined under the DPSP, the Directive Principle of State Policy. One, that we are a socialistic country, we are Gandhian, and we have a liberal intellectuals. So unlike the fundamental rights, the directives are basically non-justiciable. That is, they are not enforceable by the courts for their violation, but it is the principles for the state policy. The Constitution itself declares that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Now, when we talk about the rights of the citizens, the directive principles for the state, there are also some duties for each citizen of this country, and these are called as fundamental duties. So these basically the duties. One unique point which I want to share with you is that when the original constitution was formed, these duties were not mentioned in that. They were later at the time of internal emergency at the time of 1975 to 1977 through a constitutional amendment, and on the recommendation of one Swan Singh committee, these fundamental duties were inserted. So fundamental duties basically serve as a reminder to citizens that while they enjoy their rights, they have also to be quite conscious of the duties they owe to this country, their society, to their fellow citizens. And they are also non-justiciable in nature. So basic features, if we'll come back to again, is that we are a secular state. The Constitution of India stands for a secular state. What do you mean by being a secular state? I'll give you a very layman definition is that the state, that is the government, has no religion. Secular state means that our government does not have a religion. The government cannot be Hindu, government cannot be Muslim, government cannot be Christian. It does not uphold any particular religion as the official religion of the Indian state. So, per se, the Indian state has no religion. The Indian constitution embodies the positive concept of secularism, that is basically giving equal respect to all religions or protecting all religions equally. Then we have universal adult franchise, which talks about that Indian constitution adopts, the universal adult franchise as a basis of elections to the Lok Sabha and the state and legislative assembly. Every citizen who is not less than 18 years of age has a right to vote without any discrimination of caste, race, religion, sex, illiteracy, wealth, and so on. The voting age now has been, in the starting, the voting age was 21 years. But when the 61 first constitutional amendment came, the voting age has been reduced to 18 years. Then I previously talked about the single citizenship. There is one citizenship, that is Indian citizenship in India. Then we have independent bodies. So what do you mean by independent bodies? These days you must be, hearing a lot about that. The institutions has been destroyed. There are some institutions which are not under the government control, but they have certain responsibilities as per the Constitution of India. These institutions are Election Commission of India, the Comptroller and Auditor General of India, the Union Public Service Commission, which selects the civil servants, the State Public Service Commission. So these bodies are mentioned in our constitution, but these are independent bodies. Why they are independent? Because the nature of their work is basically being non-biased. If an election commission becomes biased, the party at the at the helm of affairs, being in the government, will never go out. The opposition will never come in a government. The Comptroller and Auditor General of India, if you remember the 2G scam, why the big we saw the headlines of 2 lakh crores of the loss happened to the Indian government, that has been brought to citizens of this country by Comptroller and Auditor General of India, Shri Vinod Rai, and then it went to the courts. I don't want to talk about what happened in that matter, but that was discovered by CAG and it brought so much uproar that the union government was changed on the charges of corruption. Then the Union Public Service Commission, if that will be under the control of the government, then all the civil servants, all the IS, IPS officers, and henceforth will be sons and daughters and the relatives of the ministers or the people at the executive. So they need to be unbiased, and that is the beauty of Indian Constitution, that these all the institutions like Election Commission, the CAG, the UPSC, they all operate at a non-biased level and they are independent. Then there is a three-tier government which I talked about. That originally the Indian Constitution provided for a dual polity, and it contained provisions with regard to the organizations and the powers and the centers and the states. Now I would like to talk specifically on the point of the latest uh, the constitutional guarantee which has come, and that is on the right to privacy. Right to privacy was very important so far as the Indian fabric was concerned, and as it did not came from the executive. Why I'm touching base upon this is that why people go to courts, and in India there is a common adage when people say कि तेरे को मैं कोर्ट में देख लूंगा, वो इंडिविजुअल जिसके अगेंस्ट लिटिगेशन करते हैं उनको भी बोलते हैं और गवर्नमेंट को भी बोलते हैं. So there was somebody who thought that my privacy is important to me, and that is how they went to the Supreme Court to decide that whether the right to privacy is a fundamental right or not. Supreme Court, after giving a due hearing through a constitution bench, declared that each citizen of a country has a right, which is basically the right to privacy, and it has to be guaranteed by the Indian government. Now, when we talk about a right to privacy, this judgment says that even taking your data needs a consent. So our mechanism has to be evolved in this country where the consent of each citizen is required if you want to take the data, if you want to approach the person. However, since 2017 till 2024, 23 in fact, Indian government took time to make laws on that. And recently, last year, the Digital Personal Data Protection Act has come, which is to be complied by all the companies operating in India and also operating at a global level who are processing data of Indians, so that they come under the ambit. And how it came to practice is that when India saw that European Union, United States of India, Singapore, they have laws which ensures the data privacy of their citizens, and they are considered to be draconian laws in terms. I'll give you one example of, let's suppose European Union has a GDPR, Global Data Protection Rules. In those rules, if a company do not adhere to their compliance process, their data privacy policy, the fines are as high as 20 million euros or 4% of the company turnover, whichever is higher. India wanted to tread on the same path, and in the same act which has come last year, Digital Personal Data Protection Act, India has also introduced penalties up to rupees 250 crores. So the companies who will not comply, who will not toe the line of data privacy in India, will have to pay such whopping amount of penalties that will be levied by central government through Data Protection Board of India. So how this transition from being a non-compliant data privacy country, being world's largest democracy, till 2023, when we are the world's top three largest economies, we were not there at a global map in terms of having a data privacy, in terms of right to privacy. This has come very late in my view, but now it has come. I think it is going to be a watershed moment in the Indian history, in the Indian history, when you know a whole of the country, and also the companies who are operating globally but with the Indians, will have to come under the ambit. And I think it is going to be a moment where the companies will feel some kind of pressure because they have to comply a lot. But going forward, let's say half a decade after, we'll see that our privacy is respected. And uh, uh, and there is somebody, there is a government which thinks that the privacy matters. So I have another 8 minutes to discuss things with you. So probably I would take you towards the few the challenges and criticisms of our Indian constitution. uh, Many people say that it is a very lengthy and very complex constitution. Of course, it is one of the lengthiest constitution of written by any country. While being comprehensive, the constitution witness it can be really overwhelming. As I mentioned before, it has almost 448 articles. I don't know of any legal expert who can with certainty say that they are aware about each and every article without referring to the book of constitution. Then we have some conflicting zones as well, like people say that there should be a federal form of government like in United States, where the president of United States becomes the powerful body and decides for whole of the country. We have the unitary system with the federal system with the unitary bias, where there is a center state relations. And there are some delays which comes because some laws comes under the center, some laws come under the state. Like there are conflicts, for example, on the GST part. So the taxation, the expenditure and revenue is a state subject, while the central taxation comes under the GST. Like for example, the water sharing. So the water sharing is a state subject. I'll give you a small example on the SYL water problem between Punjab and Haryana. Then there is problem between Karnataka as well on the water sharing. So the center is not able to decide because these are the state subjects. And when two states fight on a common issue, then it becomes an unresolvable issue. So water sharing is something which is which brings these kind of problems when we have different jurisdictions on the that who will decide on which topic. This of course comes at a federal challenges. Then many people say that Indian constitution has a certain kind of judicial overreach, or there is a judicial activism which comes in. It's a very thin line to comment upon. I would say that when judicial review gives you certain kind of guarantee that when you are not comfortable with what government is doing, what laws they are making, and if it is infringing upon your constitutional rights, then you have courts to go. But of late we have been seeing that the courts are also running the governments. For example, if you'll see, there are certain comments which come every day in newspaper. If you'll see, Delhi based newspapers, you will see that of late the courts, the constitutional courts, for example Delhi High Court, have given lot of comments that we have reached to a situation that when the Delhi government is not working, and we are forced to come in the executive decisions and decide on that. So that is when people say that it's a judicial overreach. But the high courts will have to intervene if there is a policy paralysis. People call it as the judicial activism as well. But somehow we have this kind of structure where the judicial review gives a lot of power to the courts. But so far as interpreting the constitution is concerned, it is fine. But when it comes to daily executive decisions, then I think it becomes a kind of activism or overreach. Now, why do we think that why the constitution matters and why it is considered as the sacrosanct document, why we think that it is the most supreme document of our country, is that constitution is something which is the real guardian of our democracy. It ensures that our country India remains a functional democracy despite so much of diversity and everyday challenges. It brings a lot of relevance in our everyday life. For example, fundamental rights protect freedom of speech. We have a freedom of religion, we have a freedom of equality. How does this come? This comes from the book of our constitution. Then the directive principles influence, you know like free education, free healthcare. This has been given by our constitution as well. Many governments give the free healthcare or free education to its citizen. But of course, these are guided by the directive principles of the state policy. Of course, we have a largest uh, the constitution. Many emerging democracies have looked into the Indian constitution as a model. So if we'll recap what we have discussed in last almost 40-45 minutes, is that the Indian constitution is certainly dynamic. It is not static, because I gave example of the constitution bench judgments which has come. It has, of course, it has adaptability. It is deeply rooted in the values of justice, liberty, equality, and fraternity. Most of our fundamental rights, which you will see, it is basically derived out of the basic values of justice, of liberty, of equality, and the fraternity. It empowers both citizens and institutions. It ensures the accountability and progress. The citizens can approach, the constitutional courts to ensure that their fundamental rights are not infringed upon. Institutions as well, if they think that their independence is being affected, then they also have options of going to the courts and get their rights of being independent ensured. So my, the closing thought on this can be that the constitutional is not a relic. It is actually a living document that thrives on the engagement of its people. And understanding of Indian constitution is not just for lawyers or politicians. It is for every Indian. Every Indian must understand that what guarantees we have got from our constitution, how we can enforce it, how the institutions operate, and how our country moves as per the constitution. At the end, I would like to say that in the words of Granville Austin, the Indian constitution is the first and foremost a social document. It embodies the values of justice, liberty, equality, fraternity, and secularism. These are the important constitution on which we thrive upon. I think we can have next 5 to 7 minutes for any kind of questions you want to pose. Thank you so much.
Uh, Thank you, Prateek. So we are open for the question and answer session now. If you have any questions or if you are curious about the issues that are going on in our country and you wish to ask Mr. Prateek about the same, you are welcome to do so. It is such an important topic. Like we have our fundamental rights, we have if there is any infringement that you are witnessing or you are reading in newspapers, so you have any questions related to that, you can ask the expert. Anyone? Okay. So, Akhilesh, you have any question? Yes. Shall I give you the mic rights? You can unmute and speak. Akhilesh, you can unmute yourself and speak. Okay, just 1 minute. Now you can speak. You have been unmuted now, Akhilesh. Okay, so in that case, you can write your question. Okay. No, we are not able to hear you. Okay. Can you see it in the chat, Mr. Som? It is there in the chat, his question.
Yeah, I can see he has asked. I have observed many cases where either the dominant party in two cases kindly manipulate the lawyer, how to check and act on it. I think the question is still not clear, but I would comment that, you can check on your lawyer, of course, the brief which you have given, he must act on that. And as per, the relevant laws present in this, you, of course, cannot have a absolute control over the other lawyer because he will, of course, will move as per the instructions of the opposite party. But the things in the court of law goes as per the law. So you can keep a watch on what your lawyer is doing. You may visit the court along with him. You have a right to visit the court. uh, Yes, you're writing that mostly, opposite party purchases that lawyer. It's a, very common thing which generally comes. But if you're, this is more of a societal problem. It is related with the ethics and value. You have to, before hiring a lawyer, before taking a lawyer, you must, do a certain kind of background check about, the educational credentials, about the work he has done. And that will just this is all about checking the credentials and the credibility of the lawyer. And if you are satisfied, then only you should go it. But I think your question is more pertaining to the societal problem, which of course is there. I acknowledge this. But all the lawyers in the legal fraternity are not on these lines. There are some, the problem areas which I, of course, I acknowledge. But it is like a concept of a caveat emptor, that you have to be aware about whom you are giving your brief and who is going to represent you. You have to check the credentials before giving that.
Great. Thank you so much. If there is any other question, please let me know, or you may write it in the chat. If there is any other question, Utkarsh, Utkarsh has written something in the chat.
Yeah, it's a good question. They see these all are the burning issues, which I also agree that, on the delayed justice. But there is overpendency. We are a country of almost 1.4 billion. We are almost reaching at 150 crores. So the litigation also increases with the population size. But yes, with the introduction of the tech and the IT, there is, in fact, I'll mention about the last Chief Justice. He's also Dr. D.Y. Chandrachud. He's also a Harvard alumni, and Honorable Justice Chandrachud took great steps in introduction of information technology, bringing the tech to the processing of judiciary. He was the one who deeply and greatly emphasized on the the VC culture, which has now come post COVID. And he really encouraged the bar and the bench to get into this mode of online business. On the side of the generative artificial intelligence, see, this is a very burning topic. So far as only European Union has been able to draft some laws on artificial intelligence, because right now even nations are confused that what is correct and what is wrong, so far as artificial intelligence operations are concerned. But on the personal data, I've already told you, anytime we can expect rules to be notified. The rules, maybe it is going to come in another fortnight, and we will have a very strong data privacy setup regulations in our country. I think next question is of a specific some case in
Yes,
Calcutta.
yes,
So I would not like to. These are the sub
yes,
judice matters. So I would not like. I would like to pertain only to the the topic for which I was invited.
yes.
So I
We
would like to
completely
skip this.
respect your viewpoint on this, Mr.
Yes.
Som, that it is under subjugation. So let's not discuss it over here. Any other question? So let me ask you one question. Which fundamental right you think that it is the essence of our constitution?
See, I think all the rights are basically essence of the constitution, but I think the foremost important is right to equality, right to freedom of speech and right to adopt the religious practice. These are something which, on which, that is the basis of our constitution. We all are equal, in terms of sex, caste, color, creed. There is no discrimination a state can do. And there is absolutely, in the present times, I would say that the state will also have to think about the fundamental right of adopting the religious practice. So that is very important. We have seen religious conversions and all kind of communal tensions happening in our country. So this is something which I believe that, being a common citizen, plus the government should also look into it. But these are the most important rights embodied in our constitution.
Great. And what is your opinion on the new labor code? Because I'm from the HR area, so I want to ask you about it. And what do you think that how quickly it will be implemented?
See, I personally feel that, post this third term of the government, this there has been some slowdown on the policy side and the framework. As I mentioned about, even about the data privacy laws. So this was enacted last year in August, but still we are waiting for the rules to be notified.
Yes, yes,
Right. So, there are certain laws which are there, because I believe that on the policy side, when there is a single party decision making, then it makes the decisions and judgments in a swift manner, in a fast process. But now I think it's a coalition government at the center, and government is
still,
taking its own time. But there is a positive side too, that the laws are coming, and our country needs strict regulation and policy
yes,
framework to prosper. I think labor laws also, personally, I feel there is a lot of hope with the new laws which are coming in, because old laws were very redundant, and there were no rights. Even I have seen in many cases the labor unions, or the laborers or people who want to enforce this rights, they don't get much attracted or interested in even approaching the courts, because they knew that these rights are not worth their time.
yes, yeah. So, and being, labor being the in the concurrent list, I guess there will be some issues related with the states that
Yes,
have
yes,
different
that is there. Yes,
government. Yeah.
yes. I
So
think
there's
there's one
one more
question on
question.
on the
Sorry,
divorce
Mr.
law. So divorce law is being regulated by a family laws. So it is a Hindu marriage law or the Muslim marriage law, that are the governing laws for the divorce laws. There are no specific article so far as divorce laws are concerned. Dr. Nidhi, I would have to rush for another this thing. I'll just take the last question. In corporate, we have sexual
Yes, this
harassment
is the last
policies and
question
ombudsman that
from.
safeguards the interest of both the sexes. But do you feel this is bad when it comes to marriage laws in India? So this topic is of of much interest to me. I have worked a lot even on the Me Too cases. I'm the lawyer who is the only lawyer in India who has got a clean chit for one of the accused in Me Too cases, because I believe that especially the delay in filing complaints up to 10-15 years, of course, raises some doubts on the prosecution side. In the sexual harassment, there are Vishakha guidelines which has come, and these are also judge made laws. I think post Nirbhaya incident, when Justice J.S. Sharma committee report came, and the definition of rape laws were improved upon or was changed, I think that, this is my personal opinion, but I think that came in a heat of a moment, and whole country was boiling on the incident which happened, and some laws were framed. But if you look at a holistic view, I personally feel that there is a lot of misuse also happening on these laws. I've been a counsel for National Commission for Women in Delhi High Court, and I and uh, and I've seen that a lot of cases get closure or cancellation after in their charge sheets, and there have been reports that these kind of cases have become the settlement forums. So that should be discouraged. I think courts and investigative agencies should not be used for such kind of laws.
Okay, so thank you so much, Mr. Prateek. We truly respect your time and we thank you for sparing your time to address our students. It is indeed a very interesting topic, and the discussion can go on and on because we all have, some kind of experiences wherein either we have read about some violation of law or we have, ourselves have witnessed this thing. So it was really enlightening, and you gave us many important points about the Constitution, like how it was drafted. So I believe our students will have now more respect towards the book that we have with us from 1950, I guess. So this
Yes.
Constitution, yes. So thank you so much for sparing your time. Thank you.
It's been an absolute honor and privilege. Thank you, everyone.
Thank you. Thank you, everyone. Thank you for joining the session.